Quick intro about myself. I'm first and foremost a startup lawyer. It just so happens that I've worked on IP issues for startups for the past 30 years. It's all I've ever done, actually. Not enough imagination to do anything else, I guess, but that results in having accompanied over 1,000 startups throughout my career, through all cycles of growth, from baby companies, graduate students that want to start their companies, to professors that want to start their companies, and taking some of those companies public. So IP strategies and IP issues through all cycles of growth have really, and IP strategy has been at the center of my practice. And hopefully I'll be able to share a bit of like what I've learned throughout those 30 years. And yeah, so let's drill into these slides. So the goal of this presentation today is going to be really about you hopefully understanding that the underlying value of a technology resides in intellectual property. I keep telling my clients, you are nothing but an intellectual property company. That's where the value resides. And I'll explain that in a sec, and how you need to think about IP to grow your business. All right. When I say that the underlying value of of technology is IP, it's basically because of what you see on the screen. There's different types of IP laws that give the IP owner different little monopolies. I'll give you an example. For example, patents that protect inventions. If you own the patent, you are the only one that has the right to use, sell, or make the patented invention. We'll get back to patents in a little while, how they work, what it means. But keep in mind for now that if you do own a patent, the little monopoly, and I'm putting that in brackets, that goes with that is the fact that you are the only one that has the right to use, sell, or make that invention. If you generate a work protected by copyright, software, by the way, there is absolutely no difference under copyright law between a piece of software and Shakespeare. No difference at all. They are both literary works, exact same thing. If you own copyright in software code, you are the only one that has the right to reproduce that code. That is, again, the little monopoly that's given to you by the Copyright Act. Now, if you think about copyright in the context of technology, code for sure, but databases as well, interfaces, logos, there is no difference under copyright law between a logo and a Picasso. They are both artistic works protected by copyright. And again, if you own that copyright, you are the only one that has the right to reproduce that work. One component, I'm going to try and stay away from like too many legal issues, and I really want to stick to what's important to you from a business perspective. But there are one thing you need to understand about copyright that is fundamental. What I've just discussed, having the sole right to reproduce, in my world, we call those economical rights. And those are assignable. They can be owned by a company. There is another component of copyright called moral rights. Moral rights stay with the author. They are not transferable. They are not assignable. That includes the right to the integrity of your work, which basically means that you cannot modify a work without the author's permission. Moral rights are not assignable, but they can be waived. We'll get back to that in a sec, but just keep in mind these two components of copyright as we're going to go through this session. The third important IP right is around trademarks. If you register a trademark, which is like the distinctive word or logo for that matter that you are using in association with your business. If you register that, you are the only one that has the right to use that trademark or any confusingly similar trademark for that matter in the jurisdiction where you've registered it. So it's on a country by country basis. And you can literally stop others from using the same brand or a similar brand, both as a trademark and as a trade name. Keep that in mind. We'll get back to that in a sec as well. Industrial designs protect novel designs of industrial goods. So those are really 3D objects. This is possibly protected by industrial design. So it's really the 3D configuration of an object that is protected by industrial design, which can be interesting in a world where you're working on a 3D article. And trade secrets protect anything that's commercially valuable, provided that it is treated as a secret. Fun fact, if you were to be an IP aficionado, which possibly you're not, but it doesn't matter, trade secrets are every other IP right that I just described is actually protected by statute or is the object of a law in Canada, except for trade secrets. Trade secrets are just things that have value because of the fact that they are secret. Trade secrets are the other face of a coin on which the first face are patents. In order to obtain a patent, you need to describe the invention in a patent application. Then the government gives you a 20-year monopoly on that invention as described, but you have described it. Trade secrets are going to be protected for so long as they are secret. So as part of your IP strategy, you do need to decide at one point if you have a patentable invention, should I keep it as a secret? Think what I saw in school in the 90s, which was the formula for Coca-Cola. That's always been protected as a trade secret. I am told that the heart of the Google search engine is also protected by trade secret. It is not protected by patent, despite the gazillion patents that Google own. But you do need to make that decision at one point, and we will discuss how you go about making that decision. So when you put all of those together, that is absolutely where the value of your technology resides, and that's where the investors are going to see that value. We can move on to the next slide. All right, so this is just to give you an idea in the world of software, just as an example. I do understand that you are possibly working on technology other than software, but just to demonstrate how these different things can interact with one another. So as I said before, copyright will protect the code. And if you have that, you are the only one that has the right to reproduce that code. Trade secrets can protect the valuable aspects of the software. Think algorithms, think underlying methodologies that could be protected as a trade secret. Patent rights can cover new systems and methods absolutely around your software. And one element that was not on the previous slide is know-how, which is closer to what an individual actually knows about technology, understanding the best way to solve a problem, and so on and so forth. So again, all of those will interact with one another to create value in a piece of software. Next slide, please. All right, now that we've sort of did the lay of the land in terms of IP, the topics that we're going to cover is own what you say you own, or how do I prove that I own my IP? We're going to cover branding issues, and we're going to cover also how we can create IP value for shareholders and trying to capture that value at the time of the exit while avoiding like typical pitfalls. The type of clients Justin and I typically work with are companies that need to raise money to accelerate their growth, i.e. product development and product commercialization. If they raise money with venture capital firms, for example, they will at one point exit. All shareholders will want to exit. You are all extremely aligned in creating that value for shareholders. So IP strategy for a company that's going to raise money is all about value creation for shareholders. And how do you demonstrate that you're actually creating that value as you raise money with the hope of capturing that value at the time of the exit? We'll discuss how to go about doing that in a few slides. But one of the most important topics for any startup is, do we actually own what you say you own? Because in 2024, and sure, AI is starting to create technology on its own, but I mean, it is still humans that are at the center of all of that. So if you have a human that's writing code and you have a human inventor, but you have a company that actually says, this is my technology, if you look at that through the lens of an IP lawyer, anyone actually that will be conducting due diligence for investors, as an example, someone like me who will conduct a due diligence intellectual property investigation on behalf of an investor, what we're going to do is say, okay, well, who are the individuals who worked on this? And how can the company say that it actually owns that technology, meaning the underlying copyright, the patentable inventions, and whatnot? Next, so that really goes at the heart of your business. All right. So because we are dealing with humans and the company needs to own the technology, we do need to establish what we call in my world the chain of title, which is basically the legal hoops through it you need to jump to demonstrate that all individuals that have worked on the technology assign their rights to the company if they are an employee. And if you're working with a subcontractor or a service provider, that the individual that worked for them actually assigned their rights to the subcontractor, which then assigns it to you. And all those agreements need to include the waiver of moral right that I described before. Otherwise, individuals will have retained certain rights, and then you could end up in trouble. So I'll give you one example on that, and then I'll move on to other like examples which may resonate. On logos, by the way, logos, I would say 90% of the startups that we work with have had their logos made by someone, oftentimes even like a friend, a cousin, someone they know. And there's no proper assignment of the copyright, and there's no proper waiver of moral rights. So a couple of years I represented, and in that case, it wasn't a startup. For whatever reason, it was a multinational that had a logo designed in the 60s. In the 60s, and like 8-9 years ago, they decided to jazz it up a bit to please the millennials or whatever, for whatever reason. And they modified their logo, and the individual who had worked on the logo in the 1960s sent a lawyer letter saying, hey, I did this in 1965. I own the moral rights. I never waived my moral rights. You modified the logo without my permission. I want money. So no one obviously wants that. And when I say multinational, like that logo was on skyscraper, like throughout the country. So, it can be a bit of a big deal. Investors do not ever want to get into those kind of discussions. So they will look at, have you obtained these waiver of moral rights for code, for logos, for websites, and whatnot. So it's super important to have that in place in any form of agreement that deals with assigning the IP to you and waiving those and then waiving those moral rights. The typical issues we see with assignments are as follows, and I'll give you like examples, real life stories. We sold one of our startups a few years ago to one of the top 5 tech companies in the US. You can fill in the blanks, you'll be close to the truth. So again, someone like me conducts IP due diligence, which is a Q&A session with the CTO of the company or whoever's in charge of the technology. And it's typically, honestly, quite a nice chat. We're just going through the cycles of product development. When did you start working on this? Who started working on this? Do all individuals that are employees of the company sign a template intellectual property assignment agreement? Is it always the same template? Can you send that to us for review? And it's a bit of a check the box exercise. Does the IP assignment make sense? If yes, we report to our client that it does. Chain of title is clean, move on. So we're doing this Q&A session, and the lawyer for the multinational is asking all those questions. And so the question starts, company was incorporated, let's say in 2017. Yes, company was incorporated in 2017. Cool. But you started working on the technology in 2016, correct? Yes. Oh yeah, in our basement, me and my co-founder, we started working in our basement in 2016. And when things got interesting for us, we incorporated the company in 2017. And now we're in 2022, whatever it is. And it was a success. We're selling the company. Okay, thank you. But the IP assignment you submitted to us for review is the IP assignment of employees. And by the way, if you ask any IP lawyer, I will be more than happy to send you an IP assignment for employees. But that IP assignment is forward-looking. It's anything you do as an employee of the company post incorporation. So the lawyer asks, what happens to the technology that was developed 1 year before the incorporation? Where is that? Well, it's my company, so the company owns it. And obviously that's the wrong answer. And there was actually a full year of tech development that was not captured by any agreement, that was loose in the air. The good news is all of our founders were still around. Everyone was able to sign a new intellectual property assignment form, which, by the way, if you were to work with us, we will put in place a structure that is both backward looking to capture anything that was done pre-incorporation, and also forward looking to capture everything post incorporation. That is fundamental. It's super important. So we were in a situation where the client was telling people we own this technology, and there was a full year of product development missing. They did not own a key chunk of the technology. I'm not going to go into the details, but it becomes a bit of a taxable transaction or a tax-heavy transaction. So we want to try and avoid that. The other typical issue that I see, and I was doing this exact lecture or very similar a couple of weeks ago, and I was giving the example that I'm going to share with you right now. And someone said, "Oh, I think this is my problem, like right now." Second problem that we see from time to time on, do we really own what we say we own? Again, two co-founders, let's say for the sake of the example, two co-founders, they start working for their new company, startup they created, but they're hedging, their bets. They retain employment with someone else at the exact same time, because hey, obviously you need to pay for groceries and you need to pay for rent and whatnot. So I fully get that, obviously. But that other employment agreement will have IP provisions. And remember, I hope you'll remember a few things at the end of this session, but remember this. There's basically two ways to draft an intellectual property assignment. And when you draft that, you're literally creating a bucket of intellectual property, and you say, hey, that bucket is owned by the company. That bucket can be quite well circumscribed. And that's when you say, hey, anything you do that relates to the business of the company, and if you're in fintech and you're an insurance fintech company, it's going to be anything you do in that space, in the space of fintech insurance. It's very well circumscribed. And that is assigned, whatever you do in that space is assigned to the employer. So if you have that in your employment agreement, and on the weekend you're working, your grandmother is a huge fan of bingo, and you're working on this like 4D bingo game using quantum computing and on the blockchain with AI on 6G, that's all fine, because it has nothing to do with fintech and insurance. The second way to draft that bucket of IP that will belong to the employer is not quite as well circumscribed. It's anything you do while an employee. So it will capture whatever you do on the weekend, doesn't need to be on the equipment of the corporation, and so on and so forth. So I've had situations where, again, coming back to intellectual property due diligence, where the same Q&A session, nice chat. So you started developing that IP in 2016, yes. At the time you were employed by company XYZ, yes. Can you share your former employment agreement? Oh, that's confidential, but I'll put it on the screen and I'll only show you the IP assignment with my employer of the time. And then we do the screen share, and then it's apparent that it covered everything under the sun that the person was developing. And I've had situations where we needed to go to HR of multinationals for things that had happened like 3-4 years ago, because the IP assignments were too broad and were capturing some of the stuff that the founders were working on. So just keep that in mind. We need to make sure that you really do own what you say you own. You have the proper IP assignments in place, waiver of moral rights, and let's keep track of where people that have worked on the tech have worked. If they started working on the tech in parallel to some of their other professional obligations, which, by the way, could include being a professor at a university at the same time of being a co-founder. Same issues. And yeah, so keep all of that in mind. And in your technology, you can own the IP or you can control the IP, meaning that you have licenses to whatever technology that was developed by someone else. Please keep a repository, obviously, of those licenses and make sure that they are available for due diligence. And let's make sure they are aligned with your business model. If you need like exclusivity to certain pieces of technology for your field, let's make sure you have that in place. If that's how we're going to demonstrate the value of our technology. Justin Young, you have something to add?
Yeah, Jay, and just a comment for you, because you raised the point about technology developed by a professor in a university. For our BC audience, to the extent any of you on this session are involved with UBC, for example, they have, and you probably know this, but sometimes, surprisingly, our clients don't know it, they have a very broad-reaching IP policy that will extend the grasp of the university over developed IP, and it's very extensive, very broad-reaching, and if you're not careful in how you contract around it early, it can cause significant challenges for fundraising. So that's a good point, Jan, and I think each university is different, but here in BC in particular, if you're engaged with UBC, it's a good idea to reach out to council early. We've had lots of experience, for example, negotiating licenses or assignments of IP from UBC.
Thank you, Justin. And by the way, with the scale-up IP accelerator program, these are things. So in our typical startup program, we'll look at this with you. We'll make sure that you're venture ready. So we'll do a bit of covering our bases, making sure that we have the proper assignments in place, giving you other like newer assignments if whatever was signed doesn't really do the trick. And then, but with the scale-up IP accelerator program, it's great because we can really drill down into this and work on corrective measures if any need to be implemented. Typically, again, no assignment of copyrighted logos, websites, and things like that. And then funky things around people and where they were working at the time they were creating IP, or like just plain bad IP language. All right. As I said at the onset, at one point you do need to decide what's going to create the most value between patenting something and keeping something as a trade secret. And I've heard like everything under the sun as to why we shouldn't worry too much about patents. Hey, JN, we're an AI-based company. Things evolve so rapidly in our space. Why would I worry about patents? In 5 years, it's going to be newer technologies. Hey, JN, I've heard that defending a patent in the US is going to cost millions of dollars, which it will, by the way. I mean, I'm never going to have the money to defend my patent. Why should I worry about patenting something? There's an easy answer to that one. You may sell your company to a multinational one day that's going to care a lot. So that one, but at the end of the day, I always tell my clients the exact same thing. I don't mind. I do mind if this is an assumption on which we're working on. I don't mind if it's a conclusion after having looked at relevant data. And that's what I mean by understanding that you live in the matrix. And yes, I am talking about the movie with Neo. And as hopefully you all know, at the end of the first movie, I'm going to sell the punch. In case you haven't seen the movie, even though I'm going to sell the punch, you should still watch that movie. Neo, at the end of the first movie, realizes that, oh my God, he is not living in, like, this is not reality. He's living in a simulation, and he sees the world for what it actually is. And you see that to the right of my screen. Like, he sees that. It's actually very cool. I think I saw that movie on opening weekend, and I've seen it at least 10 times since. Like Neo, so if I'm to use that analogy and bring it to the world of patents, I would say the following, and let me get my glasses. If you had the proper set of lens, you would easily and readily understand how your own innovations fit into the patent landscape. You would easily and readily understand what you need to patent, in which countries you need to patent, what and where, and to what extent. And you would understand if we project ourselves in the future and we're thinking we're going to sell our company one day down the road, you would understand the gaps in potential acquirers' patent portfolios, and you would understand how your own innovations fill those gaps. These lenses do not exist. You are not in the matrix, and maybe you are, but that's a different conversation for a different day. The only thing that does exist today, though, that can get you very close to the matrix are patent analytics tools. And again, I always work the exact same way with my startups. I do not care in which vertical they are, what's there, are they a deep tech company, a B2C play? It does not matter. I ask them for two things. Well, let me backtrack. I tell them, you have a slide deck to investors for those who raise money. And if you don't, you understand who your competitors are. If you are raising money, you'll have the list of your competitors on your slide deck, and you'll explain to investors, hey, why you're going to get a huge chunk of the market compared to those competitors. And you also have in mind, like, who could buy your company in a few years. So I ask my clients, send me the name of your top 5 competitors, top 3 potential acquirers, and then we put that in a patent analytics tool, and we pump all relevant data, which is the totality of their patent portfolios anywhere in the world, and patent litigation involving these companies. When you think about patents, and on my first slide, I think I had a reference to pitfalls. When you think about patents, both variables are important. Breadth of patent portfolios of companies in your space, and is there ongoing patent litigation in your space? On the patent litigation side, I'm going to talk about that for a few minutes. I'm almost done, Erica. We'll have maybe a 5-minute Q&A session. I'm almost done. On the patent litigation side, I'll give you one quick example. The founder of Waze at one time was making the rounds of the Canadian startup ecosystems, and I swear one of his slides was, you have not succeeded as a startup until you've been sued for patent infringement. I tell all of my clients, you are infringing on patents. That's a given, that's a certainty. I am 100% convinced that any technology company actually infringes on a patent. That is not meaningful information. What is meaningful is understanding, is there patent litigation activity in your space? And if there is, when will you be a target for infringement in your cycles of growth? So one quick example, one of my clients IPO'd 10 years ago. The exercises that I'm describing today, understanding the patent litigation landscape in your space, who's suing who, we were doing at the time. And we knew that one of our competitors was super active on the patent infringements front. We also knew that they had never sued a company that had a value less than $300 million. So they were suing people, but once they became like fairly big. So we were running with the assumption, but based on data, that we would not be sued before we would be very big. But we prepped. We knew which patents they were using. We already had a folder that demonstrated that those patents were invalid from our perspective. We had looked at the existing prior art literature that existed before. We were ready. And yes, we were sued for patent infringement. I am an IP geek. I was in Texas with them when we were sued for patent infringement. There's a thing called the Rocket Docket in Texas. It's where all these patent litigation cases happen in Marshall, a small little town. I was in front of the courthouse doing selfies, geeking out. But we were ready, and we without discussing the outcome too much, because I can't, client was happy with the outcome. So by doing this patent landscaping exercise, you're sort of seeing what's happening and if and when you can be sued for patent infringement. I did it with a startup last year where we found out that Intel was suing all of the 5 competitors she had identified, all of them. But it took us about 30 minutes to figure out that they were being sued for a module that we were not doing. And that's great, again, for storytelling to investors. If and when they learn that, we can tell them, yep, we're aware, we've been tracking this for a few years, it's not relevant to us. In terms of scope of patent portfolios of your competitors, that's important to use as a data point as you start thinking about what you should patent and in which countries and to what extent. Do I need 20 patent families? Do I need to spend millions of dollars on patents or not? If doing that exercise, we find out that someone was actually acquired for $300 million and they had one patent only in the US, well, that tells you that the market does not seem to attribute a whole lot of value to patents. So we'll possibly lean more heavily on trade secret protection as we craft and work with you on your IP strategy. If the same company had 20 patents and 20 patent families in 40 different jurisdictions, it's a completely different data point and possibly will lean more heavily on patents. And we use other data, but that's the first important data for sure. That is the matrix, and that is the starting point to crafting your IP strategy around patents and trade secrets. I'll leave you with one last example, and then we'll entertain a few questions. One of my clients, a deep tech company in clean tech, when we were doing this exercise, found out that all of their competitors were filing patent applications in Singapore. And for the life of us, we could not figure out why we would spend a dime filing for patent protection in Singapore. Keep in mind, people, like filing for patents, it's a bit like trademarks in the sense that it takes years to obtain these patents and they will cost hundreds of thousands of dollars. So you do need to be careful. But if you come up with the right narrative, especially to investors, this is why we need a robust patent strategy, then yes, proceeds of the rounds can be used for that robust patent strategy. But you'll always give some thought to, hey, why the hell, excuse my French, should I file for patent protection in Singapore? And it took my client 4 days of drilling into like different business journals and whatnot to understand in his space what was happening in Singapore. And when he did understand after 4 days, that became part of our strategy. We told our investors, hey, we need to add that country to where we will file for patent protection. This is why we need Singapore. And again, that's where and when it's using these data points that we start working on your own patent strategy. Typical pitfall is not doing that, and then so. Sorry, Erica, one last story on typical pitfalls. I have a client that kept telling me, despite the fact that it would tell him exactly what I just said today, hey, JN, no, we're a software cybersecurity company. We're not going to take patents. Things evolve too rapidly in our space. we sold that company to a multinational in the US, one of the top 5 tech companies in the US. You'll probably guess which one it is, or be close anyways. And 2 weeks before we sold that company, I was actually on vacation with my wife, first time we could get out during COVID. And so we're in Quebec City, and the client calls me, Jan, they don't want to buy us anymore. They're saying we're infringing on 10 IBM patents, 10, 2 weeks before closing. And I swear to God, if we had done the type of exercise that I'm discussing today, these patents would have come up years before. We would have built a narrative around them. Like, I'm certain of that. But instead, we needed to scramble like crazy. By the way, that company was sold. Normally, we find ways to deal with that. There are ways to deal with that stuff. And typically we'll find a way. I just hate to do it on a crisis management reactive manner. Let's be proactive about these things, people. With that, we have maybe 60 seconds for questions.
Yeah, I'll say to the audience, if there's any questions, pop them in the chat. But certainly, I think part of the intention of this session was to really kind of get an understanding of why you should be thinking about IP. I think the case was really set, right? Like, start planning now, get ahead of it, because it's much better to plan for it than to deal with big problems down the line. And so that's the intention of this program. And I'm offering up Jan's time. If you want to reach out to us to get connected on this IP program, we'd love to sit down and have a conversation with you about what you learned today and how that might apply to your business. So I think we'll leave it there, but lots of great insights. And I really appreciate Jan, both yourself and Justin, taking the time to be with us today. For folks on the line, please do consider signing up for our next WhatWorks session. It'll be after the long March break on April 4th. We're going to have Zach Cohen from Trulio come to talk about their scale-up journey. Love to see lots of you there. Again, please reach out to us about the IP program, and thanks to the Osler team for your partnership on today's session.